Today is the second in our Movement in the Mortgage Industry series. With me again is my partner, Brian Nettleingham. Brian, last time we had an overview of 3 areas in which we have broken down movement within the mortgage industry. Today, we're going to talk about and drill down into the movement of employees and groups of employees. In that regard, talk to me about movement from the employee perspective. What should the individual employee or group of employees consider when they are considering moving from one company to another?
Thanks, Marty. And I think first and foremost, it is important for that employee to understand their objective. So if we are advising that employee, that high-performing LO, as they're making a decision to move from one company to another, our first question to them would be, what are you seeking to achieve? So to the extent that the movement of that LO from one company to another is predicated upon that employee hoping to be able to achieve certain ends, we want to make sure that anything that's required for them to achieve those objectives is spelled out in their contract and that they are entitled to those things once they move. It does no one any good for an employee to move from company A to company B in hopes of achieving some objective, but then to find out that while company B might have resources that would be helpful, we're suddenly not entitled to them. Or if we are entitled to them, they're going to be used to reduce our compensation because there'll be some cost attributed to us on a P&L or other basis. So you want to make sure that that contract allows you to achieve the objectives that you want to achieve and have access to the resources that you need in order to achieve those objectives.
The movement of an employee or team of employees doesn't happen overnight. So to what extent can an employee or team of employees plan to move to a new company while employed at an old company?
As a general rule, there's no prohibition on planning to leave while you're working for your then current employer. No one is saying that you have to quit company A, then engage in this sort of pristine period of contemplating and negotiating where you're going to go, and then join company B. No, everybody has a plan when they move. What's important, though, is that you not breach any terms of your current employment agreement in doing the planning.
That is a perfect segue. It's almost universal in the mortgage industry, especially on the origination side, that key employees, high-producing loan officers, their respective teams have employment agreements. What are the key provisions that have to be considered that are typically found in those employment agreements?
There are a number, but key among them is, are you going to be breaking any provision of your employment agreement if you go on to your new company and pursue your business objectives in the way in which you intend? So, are you prohibited from soliciting customers of your prior employer? What constitutes a customer of your private employer? What about information that you might bring from one job to the other? Is it considered confidential or proprietary under the agreement or existing state or federal law? What information can you actually bring without being in violation of your agreement? And who are you thinking about bringing along with you? And is there any prohibition in your contract regarding the ways in which you can encourage someone to join you at your new company?
So, as opposed to an individual employee, put that up on the shelf. If we have a group of employees that are planning to leave together, what issues are unique to that scenario that need to be considered?
I would say the overriding concern in that situation is what I would call a staggered departure. There's a real risk that is incurred when you have a staggered departure. So, for example, and this is how we often see it, the team lead makes the move from company A to company B. And now that they're installed at company B, they begin to make the arrangements for the rest of their team to come over. In that scenario, there's a very real risk that that team lead is going to be violating their post-termination covenants and restrictions on soliciting employees from their former employer. It is almost always better if the group leaves as a group, or that all arrangements have been made for the group to depart, so that any employees who make the move first don't have to do any heavy lifting with respect to the team that's left behind. Those pieces are in place. And there doesn't need to be any communication or persuasion done during that time period.
We all know that as part of this movement of individual loan officers or teams of loan officers, that loans are the lifeblood of the transaction. So how are active or pipeline loans addressed in these movements of personnel?
It's a great question. And the best time to address this issue is when you're negotiating your employment agreement with your to-be current employer. So trying to deal with this and create a solution after you've already decided to leave your company, not a great time to be figuring that out. Negotiate that before you go in. Most companies will not begrudge you some level of what we call pipeline protection. So you leave and you've got some loans that close after your departure date or your termination date. Usually anything that closes within 30 days is pretty clearly an effort, a product of your efforts, and you would be entitled to that. But do be careful, because some LO agreements provide that once you separate from us, you're not entitled to any commissions on any products that were in the pipeline. So negotiate that up front. See if you can get 60 days. Probably not going to get 90 days, but you can almost certainly get 30 days in most cases.
So we've spent a lot of time on the employee's perspective. Let's shift to the employer perspective. If we are the hiring employer, knowing that most of your LOs in particular are going to have an employment agreement, should we inquire about the terms of that employment agreement?
It's a great question, and you know as well as I do that we represent companies who are experiencing departing employees. We represent the employees themselves in some cases, and in other cases we're representing the hiring company. From the hiring company's perspective, you probably don't want to dig too far into the LO's then current agreement with their existing employer. Instead, what we recommend, for a couple reasons, by the way. One is that employment agreement itself may be designated as confidential information. So you don't want to be enticing the prospective employee to breach their agreements to keep that agreement confidential. But also, a more effective way to deal with this is to think in a forward way about what would we not want an employee to do if they were leaving us? And then write those protections into your employment agreement such that your new employee is representing and warranting that they're not doing certain things like removing and taking confidential information, stealing clients, moving over regulated information such as PII and other types of information that would be found in a loan file, for example. Put that in your employment agreement and put it in your handbooks for new employees and in your onboarding materials that kind of behavior will not be tolerated. And that way, your hands as the hiring company are as clean as they can be.
So let's unpack that just a little bit more. What are the risks associated with hiring an employee from a competitor, again, from the hiring employer's perspective?
Depending on, a lot of that will depend on just how high a performing LO you're talking about. But let's assume we've got a rock star employee or rock star LO that we're hiring in. it will inflict some pain on the departing company. And we could well face a lawsuit that is going to accuse us of interfering with that company's contractual relationship with the employee that we're hiring. The best way to guard against liability in those kinds of suits is what we just discussed. Make sure your hands are as clean as possible, that you, the new employer, have not done anything that would be violative of law or the basic or the known terms of an LO's prior employment agreement. Don't allow them to bring in loan files. Don't allow them to openly solicit or even covertly solicit employees from their former company. Make sure that your expectations are clear in this regard. Doesn't mean you won't get tagged in a lawsuit, but it does mean that you have the best possible chances of escaping it relatively unscathed.
Let's look at the dynamics of when or how or why a LO, for example, or a team of LOs decides to move from company A to company B. Oftentimes, in that context, we see the hiring company offer a sign-on or retention bonus. Mm-hmm. How can the hiring employer protect itself relative to those bonuses?
Great question. What we recommend is, and some of this will scale depending on the size of the bonus, is that a bonus not be paid out in one lump sum, that it be paid out over a period of time, and that bonus be capable of being clawed back if that employee doesn't stay with us or is fired by us before a certain date. And again, that will scale according to the size of the bonus. We also like to see the bonus agreement, the bonus being paid under a separate bonus agreement, so that any clawback litigation doesn't have to be done within the confines or subject to the provisions of the employment agreement. It's just a straight up claim for repayment of any amounts paid under the separate bonus agreement. And ideally, that amount is secured by a promissory note.
One of the things that we see commonly within the industry relative to high-performing origination teams is sub-branding. For example, Jane Doe powered by Acme Mortgage. Okay, in that scenario, are there any intellectual property concerns when that team moves companies?
Absolutely. So first of all, does the team actually own the rights to that sub-brand? Is it theirs to move? And we're going to look at, we would look at a few things to make that determination. Let's say that sub-brand team, John Smith Mortgages, powered by their former employer. Is there a website for it? Who owns the rights to that website, that domain name, the content on that website? Has that team name been registered with NMLS? And all of that raises two issues. One, do they actually own it? And two, let's say they do, but all the indicators of ownership aren't in their favor. How do we make sure that we get those switched over so that branding can be used by that team with their new employer? Because if you don't, and it's a high-producing LO, you've just added another count to the lawsuit.
Thank you, Brian. Well, that is it for today's episode. We look forward to seeing you in our third episode, which will discuss merger and acquisition issues from a due diligence perspective.